So hi guys, I'm making a bit of an impromptu vlog today because I've just had a bunch of litigated cases where litigants in person represented themselves in the courts, but they've come to us kind of rather quite late in the process. And I'm kind of, frustrated on behalf of my clients. They've come to us, but it makes it that much more difficult for us to sort out the problem when it's, really rather late in the day, as I'm, that hoary old quote, if you fail to prepare, you prepare for failure, is especially true in civil litigation because it's so expensive down the track to fix problems that might have been made early on. This is going to sound terribly like a plug, but I'm absolutely sincere as a lawyer can be, about what it is that I'm about to tell you. The first thing to say is the courts are not in good order for, the lower value claims, the small claims, the fast track claims, even, especially now that they've introduced fixed cost recovery, the simpler end of multi-track claims, which are meant to be complex, 2, 3, 4 day trial claims. So it's worth bearing in mind that you are kind of having to, and as solicitors, we're constantly find ourselves telling the courts to do what they should know what to do, but we have to tell them what to do. I mean, Daria had a case recently where you could see the wording of the judge's order. Perhaps it wasn't a judge, perhaps it was a court clerk. It was quite a basic order. It was a bit like, we're rejecting your application for a Part 8 claim. Well, we're not rejecting it, but we are querying it. And then just basically, they get an application from a lawyer and they're not sure what to do with it. Rather than internally work out what to do with it, they just kick it back to the person who sent it into the court. And then that person has to do quite a complicated argument, a letter, an explanation on the law as to why it is that is a Part 8 claim. Part 8 claim, some of you might know, is a special form of claim in the county courts, So you're having to do a lot of hand-holding of the people who really should be holding your hand as a litigant in person. I don't know why it is that we're losing our court system. I don't know whether it's deliberate government policy. Certainly the rich are getting richer and the poor are getting poorer. And the old days when people had access to justice, people on middle incomes, had access to justice. I don't know, it's being seriously eroded to the point at which I am now developing with another law firm the idea of creating our own court, our own private court. It's going to be 10 times quicker, half as expensive, and it's not going to have all these complicated rules that tangle up the litigant in person like being caught in a legal briar bush. And I'm quite excited by this. We're now developing it. In fact, we've just approached a client whose case we think is appropriate for this type of private court to see whether or not they'd be interested in approaching their opponent and having by contact another law firm be an arbitrator judge, be a judge. And the other thing about it is I think sometimes our system is too adversarial. The lawyers don't know each other. They don't respect each other. And they burn through clients' money on arguing all sorts of points just in order to be, an aggressive Rottweiler type lawyer, ringing up the client's bill and then making it virtually impossible for to come to any resolution. What does this mean in practice, and why is this video so important? Now look, a lot of you have seen the book Flying Solo. Perhaps you've bought it. I don't know why more people aren't buying the book, quite frankly. It's an absolute snip. The amount of people who come to us when they've issued their own claims and they've been met with a strikeout application and a costs order from a judge to go away and amend their claim for 1,500 quid, and they're confused. If they'd bought the book for £38 or £50, they'd have headed off that problem because there's a big section on, how to properly particularise your claim and avoid strikeout applications, as well as addressing the critical point of issues in civil litigation, which I'm going to come on to in one or two vlogs time over the winter period. Now, if you look at the book cover of Flying Solo, it's not just some funny cartoon metaphor, to sell books, or because people identify themselves with a shaggy dog and a pair of flying goggles, in a Spitfire. It's because it's a very good metaphor for the problem, the central issue around bringing your own claim in the county courts of England and Wales. It is like civil aviation. It's not like riding a bicycle or a motorbike or even a car. Your 13-year-old kid could probably drive a car, but they'd never be able to get an aeroplane into the air. This is because of the complexity that the powers that be, God bless them, have built into the system. It's a lot to do with the civil procedure rules. Parliament thinks that by creating more and more and more rules and laws, and then more rules and laws on top of the existing rules and laws, and tweaking those rules and laws through the Civil Rules Procedures Committee, they're going to make everything simpler. Duh. Which makes me think, I'm wrong, they must be right, there's some big agenda, they're trying to make it complicated, so that they drive everybody away from the county court system, some Orwellian future where you have to pay for a judge. And then the government doesn't have to find however many hundreds of millions or billions of pounds each year for the Ministry of Justice's budget. I'm in danger of becoming a conspiracy theorist. Well, as many of you know, I probably already am. What's the significance of that Spitfire analogy? I'm seeing this with the cases. I'll come on to the cases in a moment. I'm seeing people who are like stunned, like rabbits in a headlight, in front of a judge in an interim hearing, because the judge has just sort of steamrolled over them, ordered costs, vacated or relisted or adjourned, or worse, made a ruling against them. And they're like, but I've got a good case. I've got the law on my side. I'm in the right. Sure, you may have a good Spitfire. You may have justice on your side. You may have genuine merit in your claim. But if you haven't figured out the control tower, that the right runway, the ground rules for getting an aeroplane into the air, let alone how to fly an aeroplane itself, you're taking a risk, to put it mildly. I'm talking about, fast track or multi-track claims, small claims, unless they're specialists like financial mis-selling, for example, fine. You should it's more like a bicycle or a car, or a glider or whatever. You should just get the thing in the air on yourself and use free resources and materials to help deal with various issues, because on the small claims track, each party bears their own legal costs, even if you win, so you don't have that problem of legal costs, which is the big elephant in the room often with litigation. So let me just give you a few sundry examples of cases where we're helping, or cases where we have helped people over the past couple of years, or are helping now. I've got, the first one here is a possession case. I've got a client who's in danger of having his house possessed. He contacted us a few weeks ago. He had a hearing on last week, which was very close to having the judge making a possession order. But for over a year, he's been in the court system, the mortgage company having issued proceedings against him. He's got a defence. We don't know how much merit it's got in it. It may not have much merit, it may, but it's quite a complicated kind of defence. I don't want to go into the details of region of confidentiality, because this is still a case that's ongoing. But you can see my point. If from day one he properly researched the legal position, understood the way that the court system works, he wouldn't be having sleepless nights right now, quite frankly. strikeout cases generally, I mentioned that at the beginning of the vlog. That is quite a common issue, and that's why I've got a section in the book about it. What people fail to realise is that a claim is not allocated to the small claims fast track, multi-track, intermediate track now. Watch the last vlog I did on fixed cost recovery. And what happens is they may think, for example, that their claim is a small claim of under £10,000 value, half a day trial. But there's this gap. You issue your particulars of claim, you get a defence, you get a directions questionnaire. There's actually quite a lot of work done already. And plus the pre-action costs, if you're suing a well-heeled opponent who's instructed lawyers, and then you discover that your opponent, particularly if they're a corporation, files and serves a strikeout application against you before it's been allocated to one of those tracks. And even though it might then go on to become a small claim, suddenly you find yourself in front of a judge with a barrister on the other side. You haven't properly particularised your claim or your defence. Might be summary judgment rather than strikeout, but it's usually a strikeout application. And the judge tells you to amend your particulars of claim, and then he comes on to costs and is like, okay, he looks to the barrister, and the barrister says, well, we want our costs because this claim hasn't been properly particularised or properly brought. Oh, okay, how much? We want 1,500, 2,000 plus VAT. So that happens quite a lot. And again, you've got a spitfire, you've got merit, but the other side have already got you on the back foot. It is a game, it is a dogfight, bringing a civil claim. And you are £2,500 down and you're stunned. Yeah. We've got a personal injury case where, again, a litigant in person has brought it herself. I mean, I don't blame litigants in person for bringing their own claims. They've got to, because lawyers are so expensive, and because of these changes in the rules, they're not able to recover the maximum, the full amount of costs that they might have incurred, the amount of legal costs that they've incurred because of these new fixed recovered cost rules, which cap the amount of costs, lawyers' costs you get back, even if you win. And even if you've gone over the cap, because it's entirely reasonable and necessary, you still don't get your full legal costs back, which might make it a non-commercial endeavour to fight it all the way to trial. So, I actually think the fixed recovered costs change is good for litigants in person. I think it's going to inevitably mean that good for litigants in person, because your opponent has, if they're instructing lawyers against a litigant in person, they're worried that they're not going to get their full legal costs back from defending or bringing a claim against you. And therefore they're more likely to want to resolve it and settle early in your favour. So that's another example where there's a problem if you haven't properly eyeballed the civil procedure rules as it relates to your type of case before you launch the aeroplane. The case that I'm referring to is a personal injury case. And unfortunately, this person is quite a long way down the track, but they didn't write a proper letter before action. Yeah. There's a specific pre-action protocol for personal injury claims. If you issue a personal injury claim without having followed that pre-action protocol, then you're in danger of not getting your costs back. I mean, the court could even sort of strike out your claim and tell you to bring it again or make some cost order, because you should have tried to settle before issue, and that means, as far as the court's concerned, a fully compliant letter before action, compliant with this specific personal injury cases, specific personal injury pre-action protocol. And it's in our case, actually, it's problematic because it's we approached we're not personal injury litigators. We advise personal injury cases and we deal with complex ones, but we don't offer no win, no fee on personal injury cases. So we wanted to find a no win, no fee personal injury law firm. We know one, we found one now. I like them. And they said, well, we can't do it because of this failure to comply with the pre-action protocol. It makes it sort of financially impossible for them to do it and creates problems. Building disputes, well, we have a lot of those. Classic case situation here, well, I say classic, common. That's where our case is on the fast track. It was issued by the client on his own, and then eventually he instructed South Bank Legal, which is the law firm where, if on the occasions that we do act like an old-fashioned law firm and litigate on behalf of clients, we do it through South Bank Legal. And the problem there is it is in danger of being classified as a small claim when it's on the fast track, because the client hasn't disclosed evidence, in this case invoices, that proves the full value of his claim, and therefore it's a claim that's well below 10,000, simply because he hasn't complied with disclosure of relevant documentation. Here's another example of the problems that you have with the court system. I was talking to a contact at another law firm, a litigator, and they had a hearing vacated by consent, and they drew up a consent order with the other side, and the judge says, just file it at court, and the court will rubber stamp that there's now no longer the need for another hearing because we've agreed the issues at this hearing, only to discover that the court hadn't updated their records, that if and when they got the fully signed consent order through after the hearing, that then they should tell the judge the next hearing had already been listed is vacated. So this lawyer rang the court up 10 times between the time that this consent order was agreed and signed, in order to avoid going along to a pointless hearing, which was in the court calendar. Couldn't get through, couldn't email, impossible to get through to the court. Everything now goes through a central call system, and because they're understaffed and underfunded, they don't get round to things. It's not at all like, a private professional, like a private sector business. And he had to go a reasonably long journey, I think it was between Nottingham and Cambridge, for a hearing, only to arrive prepared for that hearing. The first thing that the judge says is, oh, this hearing shouldn't be active, it should have been vacated. Duh. That's like 5 hours of the client's money down the tubes, because you've got to pay for your lawyer to go along to a pointless hearing. So this is, to reiterate, one of the big problems is, a court system which is just unfortunately increasingly not fit for purpose, frankly, unless it's a high enough value claim, because rich people or rich corporations can pay for justice. I mean, it cuts both ways. It's a dogfight. Your opponent could equally lose out. You could lose out, and actually, that's what these videos and all this advice is that we give, and why we are routinely we attend hearings. Daria attends hearings. We don't farm them out to other people, so we get a feel for what's happening on the ground, because you want to advise from people who are actually in the trenches. So just to sort of a point of analysis here, and that is that it's all about communication. What people need to understand is you have these interim hearings in civil litigation. Yeah, you might have a 10-minute preliminary hearing on track allocation and other issues. Depending upon the size and complexity of your case, you may have pre-trial review. You often have various applications on it and 244s listed for 45 minutes or something. You might have one of these strikeout applications. You will have in a multi-track claim of costs and case management conference. These are all really important interim hearings along the way to trial. Opportunities for settlement, opportunities for closing with the issues. What people fail to realise is the judge does not have time to get to know that you have a spitfire, that you've got a strong case. He's not going to go through all that paperwork in the 15 minutes that he's got allocated to read up before he goes into court with you. So the really important takeaway is, other than being prepared, once you're prepared and you've launched the aeroplane off of the right runway and the right flight plan, you've got a basic understanding of the controls, when you hit a bit of turbulence at one of these interim hearings, you need to be able to quickly and efficiently and concisely communicate the strengths of your case. And you need to understand that invariably these interim hearings are not about you soapboxing about how strong your case is, but playing the procedural game. Yeah. So to give an example, you might think you've got a really good defence, but there is let's say a possession claim, but actually all the judge is concerned with is if your opponent, the mortgage company, has provided the correct proof that they own the mortgage, the arrears, the exact amount that the claim has been, because there's a pre-action protocol for possession claims brought by banks, that they've crossed the T's and dotted the I's, yeah? They're not concerned about whether you've got a defence. Let's say you've been missold payment protection insurance on the mortgage, yeah? That would mean that there aren't arrears. In fact, the bank owes you money, But people fail to realise that interim hearing, and people really need to read court orders, incidentally, is not about you soapboxing about how dodgy and fraudulent your opponent is, but playing the game a little bit and understanding that if you can find a weakness in, let's say, the way that your opponent has brought the claim, perhaps they've brought it incorrectly. Perhaps they haven't provided a notice of assignment from a previous lender who sold it to them, or they haven't properly particularised the losses, or they haven't disclosed information on the payment protection insurance that was on the mortgage. It's not about whether it was wrongly missold to you. It's about whether you've had the documentation disclosed so that you can prepare a proper defence. So you're asking the court, let's say, for time, and that this hearing has been a waste of time, and therefore the judge should order costs against your opponent for organising a hearing that would have been unnecessary if they'd provided the data and the disclosure that you needed to particularise your defence or counterclaim. Do you see how people miss what interim hearings are all about. Right, okay. So therefore, any documentation that you are putting before the court, which you should copy in on your opponent, needs to be consistent with, so in that instance, it would be you file at court the letter that you sent to your opponent requiring them to disclose information about the payment protection insurance on the mortgage. Yeah, and you say to the judge, look, here's the letter. You don't give the judge 100 pages of evidence on financial mis-selling insurance and how it's a scandal and newspaper articles and what's been said in Parliament and and a 50-page case. You just provide a letter and a follow-up letter, and you say, Your Honour, Ma'am, Sir, we want you to order that unless they disclose this information, their claim will be struck out within 21 days, and we want costs of today. So that's why, and now to wrap up and to return to this civil aviation analogy, that's why you need to know a little bit about aeronautics, aerodynamics, how airports operate and what tracks, what planes, what runways different planes use to take off, what procedures comply. Now don't be too kind of disheartened. This is just about getting the plane in the air, This is about, so here's the solution. This is about, if it's a simple claim, watch some free videos, get a free book, buy a book like Flying Solo. If it's a little bit complicated or higher value, find a lawyer or a support service like Court Wingman, book a £150 court surgery. It's not that much if it's the claims 15 grand. And make sure that you are on the right runway with the right flight plan. Also, perhaps you get someone to help you, maybe get them to draft or maybe check what you've drafted, the particulars of claim and the defence, so that I guess it's a bit like having a maintenance check before an aeroplane takes off, because that document is a critical document in civil litigation. It's all about the paperwork. But once you've done that and you've got your plane launched, you're in a far better situation. You're properly prepared, and you can have top-up legal advice along the way with a support service, or just read the relevant chapter of a book. I told you it was going to be a bit of a plug video. Or, if you're a cheapskate, watch one of the free videos. There are probably around 100 of them on our YouTube channel. So, finally, for the cheapskates, you can get a free introductory chapter of the book. You can also get what I think is quite helpful for people who don't know whether to get legal, use a lawyer, or whether, to even turn up at the airport. And that is a decision flowchart, which I did a while ago, earlier this year. And if you go onto the homepage of the website, or the books, handouts and free advice section, you can just return for your email so we can spam you. You can unsubscribe at any time. You can get the decision flowcharts, which I think help people make a decision about how best to manage their case. So there it is. As I say, and let's try and summarise. The courts are in a bit of a mess. That could be an advantage if you know how to fight the fight and play the game properly. However, in order to fight the fight and play the game properly, I'm afraid the civil aviation metaphor applies. It's not enough to have a Spitfire. You need to understand how to navigate the civil procedure rules. But you don't need to go over the top. If you are going to get legal advice or read books or watch videos, do it earlier rather than later, because it's much more expensive to change things down the track than it is early doors. The two key principles in dealing with this court system are both to be prepared. You know, classic example, what track your case is likely to be allocated on, what value, what level, what sort of complexity there is involved. And that's kind of advice early on. And drafting the critical statements of case. After that, the next most important thing is to wise up about what happens at these interim hearings and how to manage these interim hearings. And I will talk more about that in a vlog on issues, because if there's one area I think that litigants in person need to really close with, it's the area of properly identifying the issues in your case. Okay, there's a lot of good, useful, free materials on our website. Courtwingman.com really is, I'm trying to make it the proper home for people who are representing themselves, as well as for people who, perhaps even lawyers, who just want things simplified for them. And so I do highly recommend you go onto that website, and don't be a total cheapskate, buy the book. It's been written for litigants in person. I try to write it as if I was a litigant in person. And don't be, penny wise and pound foolish. So that's all for today. I hope that has been of use. Bye for now.